conditions would permit polygamy. On European soil, polygamy is prohibited. So in many states, it is even a crime, punishable. And there might be good reasons for that. Nevertheless, so on European soil, such a polygamous marriage cannot be entered into validly under European laws. But how to deal with people who are married in a polygamous marriage validly under the respective foreign laws, and then coming to Belgium, coming to other European countries, how to deal with them. And there, most of the European legal orders, not all of them, there is a certain conflict, have decided to look at the concrete case, which means we differentiate first between immigration issues and private claims. For immigration, the second marriage is not valid. So we don't consider it. So, of course, the second wife may immigrate, but as a tourist, not as a wife. Otherwise, if we would decide otherwise, we would encourage people to enter into polygamous marriage just for immigration issues. But in private life, if they have been living together for decades, let's say, and then they are living here, if we would say in our courtrooms, we refuse any kind of polygamy to be dealt with in our courtroom, the outcome would be that the second wife cannot claim maintenance against the husband. The second wife of the deceased husband will not participate in the estate inheritance. The second wife will have no claim to social benefits which were acquired by the husband himself, not by the community, not by the organization as a whole. So in most of the European countries, the trend is to say, while we reject polygamy as an institution, for the sake of this concrete person, of this concrete second wife, we accept her claims as long as they are directed against the husband. So we don't deprive her from her rights against her husband as it comes to maintenance, inheritance, etc., etc. This is not an approval of the institution of polygamy. This is a help for this concrete woman. And if you would decide otherwise, and we have now the debate in French courts now, they changed since 2004-05. Austrian courts now decide else. They would say we would not accept this institution anyway. Well, then you can say, okay, we are holding the flag. No polygamy. For good reasons, of course. But does it make sense to decide on this abstract level and then to disregard the interests of the individual? Me having been a judge, I have learned to look at the individual. And if you make it clear, that by granting her maintenance claim, we do not accept the institution the claim is based on, but she relies on that and she trusted that she would get the money, and then in the evaluation of the bigger and lesser evil, we would say, let's give her her rights against the husband. But this is the debate in Europe, and just by the way, since a number of years I try to explain to the European public how European legal orders are dealing with these issues. I do it very often in Germany where journalists are interviewing me. And there's one leading German feminist, Alice Schwarzer, who decided then to blame me to be one of the major proponents of Sharia, to replace the German legal order, etc., etc. I received a death threat, and several other things happened simply because I tried to explain the existing legal system, which I didn't create. But you see how intricate the debate can be. I mean, you see, I just continue. But nevertheless, it was a lesson for me to see, and I think it's our task to explain to people. It's not easy to understand that. Private international, who knows that? What we are doing when we are dealing with these things. And if we explain it thoroughly, I think many people would understand and would follow this path. There are some other areas now where institutions of Islamic law are emerging, because more and more Muslims are no longer foreigners in Europe. They are European citizens, and usually they would fall under the domestic laws of the state they are living in. But nevertheless, if, for example, a Muslim couple wants to enter into an Islamic marriage contract, which contains very often a so-called dower provision, an amount of money usually to be paid by the groom to the bride. Is this valid under Belgian marriage law? The marriage laws of other states? And then you have to evaluate. Usually there's freedom of contract. Why shouldn't you implement marriage contracts are possible? Why shouldn't you implement such a provision? Is it detrimental to anything? Is it an infringement of good morals? You can't really see any problem if the groom promises to pay a certain amount of money to the bride, particularly in case of divorce, which is very widespread under Islamic law then. It's just helping this woman, especially in cases where they decide to leave Belgium and to continue their lives in an Islamic country, where this will gain a lot of importance under legal terms, because there you have these patriarchal systems of family law, and then the wife is supported by this additional payment in case of unilateral divorce of repudiation by the husband. So there is no reason to prevent people from entering such provisions into marriage contracts. I mention that because there were some lower courts in the past who said, oh, this is a sales price for the bride. Such things occur as well. We do have it in eastern Turkey, Bashlik, we have it in Yemen, Shat, and other institutions which really would be a sales price. And of course we cannot enforce sales prices for human beings in our courts. But this is simply a kind of promise, an legally intricate one, because its functions are not very clear very often, so you have to thoroughly look into the case, what is really the content of this promise, but nevertheless, usually it is accepted. Take Islamic economics. We have forms of Islamic economics now on European soil. We have Islamic banks, we have Islamic investment, we have sukuk, we have all sorts of things. 4 years ago there was an article in the Osservatore Romano, which is not a Salafi newspaper, praising the Islamic way of economics, if they take it seriously, which is against speculation. I mean, all this financial crisis was based on speculation. 97% of the money flow all around the world was not based on real exchange of goods, but only on sale of money for money, for money, for money, virtual things. There was a lot of virtual money, it's gone now, no one knows where to. But nevertheless, those institutions in the Islamic scene which rejected to invest in this kind of speculation did quite well during this crisis. So there is no reason at all to prevent that. If you want to invest your money Islamically, which means no pork, no pornography, no alcohol, etc., etc. So why not so? In the US there is an Ave Maria fund, Christian one of course then, which I would highly praise, because they would donate some of their income to ailing law faculties, supporting them a little bit. So ecologic banking, etc., etc., all sorts of ethic kind of economics is possible. To conclude, is there a necessary contradiction between Sharia and European laws? No. It can be a contradiction, but not necessarily. Sharia is dependent on the interpretation of the Muslims, of the respective Muslims. We should listen to them. What do they want? What do they want to implement? For whom? Is it a religious issue? Then it's protected by freedom of religion within its scope. Is it a legal issue? Then we do have our clear rules on application, on the application of foreign laws or of internal laws within the limits of good morals. And first and foremost, being scientists, before decision making, we have to have thorough information about what we are going to decide on. And there is still a lack of information about what Sharia, in all its complexity, is and means. And if we want to reach more cohesion, more exchange of minds, less conflicts, I think we are all in need of searching overlapping consensus where it is to be found. And there is a lot of overlapping consensus if you look thoroughly into our legal orders. we shouldn't play down the differences. We should address them. We should be very firm and clear in our principles. Every state in the world has the right to defend its basic principles. We will not negotiate democracy. We will not negotiate the rule of law. We will not negotiate the catalogue of human rights. But freedom of religion, freedom of conduct are integral part of this human rights system. So it's far from being necessarily we and the others. And at the end, I think why Huntington was so terribly wrong with his clash of civilizations is the idea that there are some essential cultures which are immutable, which are homogeneous. And my lifelong experience, I spent a number of years in Islamic countries and in other parts of the world. My experience is that we so often meet in basic human needs. If you are asking people on the streets, do you want to fight each other? What are your main goals? Coming back from Cairo, people are struggling hard to earn a living. The economic situation is really bad. People want their children to have a good future, maybe a little bit of better life than they have themselves. So there are these basic human ideas are so equal, despite all the differences we do have, of course, that I think we should discover the richness of this common basis to develop an amount of mutual trust and to discover that we all are multiple in our minds, in our attitudes. We are not only a religious person, Christian, Muslim, Jew, etc. We have so many ideas, we have so many individual convictions that we should develop this richness and then to find out where do we have our allies for promoting human rights standards and where are these people who don't want to agree. And I think if we try to proceed this way, we cannot avoid any kind of conflict, but we can diminish a lot of them, and I think this is one of the most important tasks of lawyers and of society as a whole. Thank you.